Good morning and welcome to the 12th meeting of the Citizen Participation and Public Petitions Committee of 2025. Our colleague David Torrance, the Deputy Convener, will be joining us shortly. Our first item of business is simply to agree that we will consider our evidence under item 3 in private. Are colleagues content so to do? We are. So our specific reason for meeting this morning with this additional meeting of the committee is to take evidence on youth crime, and we have two panels with whom we hope to be able to explore the issues. And it will be informed by our consideration of two separate petitions with which we've been actively engaged since 2022. The first of them is Petition 1947, which is to address Scotland's culture of youth violence. During the evidence sessions for which we have undertaken external visits and met with different various groups outside of the Parliament. And petition number 2064 to ensure that under-16s charged with rape are treated as adults in the criminal justice system. And to assist us in our consideration, and on this first panel, I'm delighted to say we've been joined by the Right Honourable Dorothy Bain, KC, the Lord Advocate, who's a great pleasure to have back with us at committee, with Alistair Hogg, the Head of Practice and Policy for the Scottish Children's Reporter Administration, and by Stephanie Ross, who's Principal Procurator Fiscal Depute in the Policy Unit, the Crown Office and Procurator Fiscal Service. So really a warm welcome to you all. Thank you very much for making the time to join us this morning. So I'd like to start just by setting out some of the context to which I've been referring. The committee's actually undertaken a considerable amount of work on this petition to address youth violence and has been struck as we went along by the sort of similar concerns that were being raised in parallel on the petition about rape committed by under-16s. On the violence, the youth violence petition, we took evidence from Police Scotland, the Violence Reduction Unit, and No Knives, Better Lives, and we took evidence from a number of academics. Most notably, we visited young people and their families impacted by violence in their own communities. Following attack when she was just 14, one girl we spoke to, and I don't think any of us who were there will forget it, and I suppose it's not normal for politicians necessarily to be confronted by that level of direct experience. Others will perhaps say it's a story they've heard before, but we were left profoundly moved that she was left at the age of 14 with PTSD, cannot leave the house without her mum, and attempted to end her life on 2 occasions. Perhaps, and as we get through the evidence, we'll go into some of what we were told at the time. This young girl and her family, they do feel let down, that the justice system didn't protect her, and that after the attack, it was just as bad. And she didn't feel that there were appropriate consequences to the perpetrator, who was still very much in the community and able to, along with their family, cause her further harm. The petitioner for P 2064 on rape committed by under-16s has shared a view that there should be more consequences for the crime of rape committed by under-16s, and she feels that the perpetrator will be free to continue attacking more people because, as she sees it, there is just no deterrent in place. Now, the committee understands that the system avoids criminalising children where possible. However, we remain concerned about how the most serious cases of violence and sexual offending are addressed, and crucially, how victims can meaningfully pursue justice and feel safe again in their communities. Now, I suppose, finally, I suppose we were particularly struck by the organisation of some of the violence that we saw. Individuals who were falsely summoned to destinations to find multiple people standing present and ready to film what then took place, and then abandon the victim pretty much without regard to their well-being or safety whatsoever, and in really extremely difficult and dangerous condition. And it was very difficult to hear. But before I start, I have been told that there's no request to make an additional statement. No, we're just going straight on to questions. So I'm going to invite Maurice Golden, because I'd like to come to the bit about victims and the evidence we heard from those children later. So I'm going to invite Maurice Golden to begin the questioning this morning.
Thank you, Convener, and welcome, panel. I just wonder if you could outline the approach taken when serious violent or sexual offences by children under the age of 18 are reported to the police.
Do you want to start? I'll start. I'll be happy to start. That's okay. Yeah. Good morning, committee. I guess I would start by referring to the Lord Advocate's guidelines, and Lord Advocate is obviously here and can speak to those guidelines. But so far as the police are concerned, they begin obviously with their own investigation, and when they consider that there is sufficient evidence, they will then consider how appropriate to direct that concern. The Lord Advocate's guidelines give the direction in relation to what the police should do in those circumstances, and the first thing to refer to is that the guidelines recognise when there is a child involved, and recognise that children should not ordinarily be prosecuted through an adult criminal justice system, but instead should be considered through the children's hearing system, which is a more appropriate welfare-based approach for children. But the guidelines recognise that there are some circumstances where, as has been stated, there is particularly serious harm that has been caused by a child, and sets out which situations the police should jointly report that young person. The joint report will come to the Crown Office Procurator Fiscal Service and to SCRA. There is then a joint agreement between our two organisations, which is publicly available and certainly on the COPFS website. And it's a very comprehensive document. It outlines the process that is taken, the care that is taken to consider those cases, the criteria that are considered when considering what is the appropriate route for this incident to be directed towards. Broadly, the definition currently of a child is anyone under 16, but there are also some 16 and 17-year-olds who meet the definition of a child if they are on a compulsory supervision order through the children's hearing system. So they're all covered through the Lord Advocate's guidelines. And there are some other circumstances, such as if you're 15 or over and a road traffic offence, which may attract disqualification. The process that's followed is that the children's reporter is required to provide information to Crown Office Procurator Fiscal Service. There is a template which directs what type of information to provide. All of the details are contained within the joint agreement. They're there for everyone to see. And it covers things like what is the current status in relation to the hearing system of the child, what are their known circumstances, is there any current supports or intervention in place, and what might be available through the children's hearing system if the child was referred to the children's reporter. The decision about which route to take lies with the Procurator Fiscal, and there is in place a presumption that because this is a child who has been jointly reported, that they will be directed to the children's hearing system, but that can be rebutted, can be overcome, if the Procurator Fiscal considers that to be in the public interest. And again, there are criteria which direct what type of circumstances that consideration would be. And obviously things like the seriousness, the gravity of the offence, the impact on the victim, criteria like that are high in those considerations. So some children are prosecuted and some children are referred to the children's reporter, and I can go through the children's reporter's process if that's something you want me to go into.
Yes, perhaps, but if we'd perhaps hear from the Lord Advocate, because I'm certainly aware of the recent statement on prosecution policy, and perhaps you could wrap that in as well.
So dealing with the cases that are reported to the Crown Office, the cases reported by the police operate under guidelines that I have issued in order to determine whether or not the case is reported either to the Children's Reporter or to the Crown Office and the Children's Reporter jointly. Children who are reported to the Crown Office and Procurator's Fiscal Service are often the most vulnerable children in Scottish society. Many of them have suffered trauma and may be experienced in the care system. So decisions relating to children who come into contact with the law must be taken into account by reference to the rights, needs and best interests of the child in line with the UN Convention on the Rights of the Child, whilst also balancing the rights of the victim, who will often also be a child, and the wider public interest. So there is a need to strike a balance between supporting children who come into contact with the law and ensuring that victims are supported and that communities are safe. All reports involving violent or sexual offending are treated seriously, and where such offending merits prosecution, action will be taken even when the offender is a child. So the prosecutorial response to children and adults needs to be different, and fundamentally a child is treated as such because of the impact of their age and maturity. Also, these aspects have a bearing on the assessment of their culpability and the potential for them to change and to be reintegrated into society, and ultimately reducing the risk of reoffending. So the presumption, as Mr Hogg has said, is for all children not to be prosecuted. However, that is not to say that a child cannot and should never be prosecuted, nor does the UN Convention of the Rights of the Child dictate that children accused of crime cannot be prosecuted. The presumption against prosecution is a rebuttable presumption and should be rebuffed when it is in the public interest to prosecute. The more serious the offending, the more likely it is that the offence is prosecuted in court. In particular, given the seriousness of the offence of rape and other sexual offending and the impact of such offending on victims, referral to the reporter or diversion from prosecution for such offences will only be appropriate in certain circumstances, and these circumstances are also outlined in guidance available publicly, in which set down these parameters within which Council determine a case should be diverted from prosecution. So fundamentally, I would say, in relation to children, the justice system must be responsive to vulnerability, trauma and needs, but it also must be clear that serious offending has serious consequences.
Thank you. Stephanie, would you have anything to add? No? Okay. I think, Lord Advocate, it strikes me that the presumption against prosecution in these cases is perhaps out of kilter with what public opinion, because the scope of which we're discussing is serious violent or sexual offences, and I understand the whole system approach is around early interventions at the first sign of difficulty, and I think there's a logic to that, but I just wonder where we're dealing with the most serious cases of violence and sexual offences, that the crisis point has perhaps already been reached, and therefore the consideration of that should be viewed in that context. And just wonder your thoughts.
So it is a rebuttable presumption, and as I said, the more serious the offence, the more likelihood of a prosecution. And so you are particularly now identifying a category of cases, serious sexual offending, that are treated with the utmost seriousness by the Crown Office and Procurator Fiscal Service. And it is the case that children are prosecuted for these offences, and they have been, and in accordance with the principles set down in relation to how prosecutors approach the issue of diversion or the question as to whether or not to refer to a reporter, cases of allegations of violence and sexual offending by children are considered by dedicated teams of prosecutors who have specialist experience and knowledge, and each case is analysed with great care on its particular facts, and the decision whether or not to prosecute is taken in accordance with the prosecution code, which is publicly available, and a decision is made as to what action is appropriate when one considers a public interest. And it is the case that these serious cases are indeed prosecuted in the adult courts.
But the presumption would be that that would be for the most extreme examples in what is a very serious and tight scope. Would that be the case?
No, I don't think that we could put it. We could set the test like that. The most serious examples. I think that, for example, when we looked at the issue that was raised in and around decisions to divert children from rape prosecutions, we obviously looked back at all the cases that had been diverted, and we've issued new guidelines in relation to these decisions in these cases, which are now, after my review, taken by Crown Counsel. But we're not talking about the absolute extreme of cases. We're talking about cases where the child has offended and committed a serious sexual offence. We have many serious sexual offences in the court system, and depending on the circumstances of the case, we will prosecute. So rape is a case where that is an entirely rebuttable presumption that we would proceed to prosecution, or serious sexual violence is one that we would look to proceed to prosecution where it's appropriate in the public interest.
Thank you. And in terms of diversion from prosecution, what support is available, particularly if you're under a compulsory supervision order, and is there sufficient resources across the whole of Scotland to provide that?
So in relation to a child who's under a compulsory supervision order and who's referred to the children's reporter for an allegation of rape, perhaps Mr Hogg could come back on that. That really probably is within his remit, whereas we are prosecuting in court the decision to take the child out of the adult system and to deal with it in the children's reporter system. The question of resourcing, support and the method of dealing with these children really lies with the specialism that Mr Hogg's team has.
I might come back on you about that, because obviously to set the policy you're required to know the other side, even though that's not the part that you're delivering. But yes. Mr Hogg.
Yeah, and the collaboration between our two organisations is absolutely comprehensive. And in every single situation where there is a joint report, there is an exchange of information and very often a discussion that takes place. And that will be proportionate to how significant the incident or the joint report refers to. Just make a distinction between diversion and referral to the reporter. Referral to the reporter is specifically for children, and currently there are parameters to that. Referral can only be for a child who's under 16, or if they are already on a compulsory supervision order up to the age of 18. That will change under the Children Care and Justice Act when those provisions are implemented, but they're not yet implemented, and that's the current position. So when there is a referral to the reporter, you were asking specifically about supports that are in place in relation to compulsory supervision order, and that would be following an investigation by the children's reporter into the whole circumstances, considering all of the child's circumstances. I can go into lots of detail around how we do that. We have a decision-making framework which is very clear and very comprehensive about how we do that, and has come to a conclusion that, first of all, there is sufficient evidence of a ground of referral, any ground of referral for a children's hearing, and most of those grounds are not based on the child's behaviour. They are based on concerns about the welfare of the child. If those concerns are there is sufficient evidence of them, and there is a need for compulsion, then the children's reporter will refer to a children's hearing, and at the children's hearing, the children's panel members will make the decision. If a compulsory supervision order is put in place, then that places a duty on what's called the implementation authority, which is usually the local authority within which the child resides. And they have a statutory duty to provide those supports and interventions as is directed by the care plan that the children's hearing will have had sight of. A compulsory supervision order can contain conditions that can be attached to the order. Those conditions must relate to the child, and those conditions can be really anything that is considered to be in the best interest of the child. Sometimes those can be pretty significant interventions in a child's life. For example, that the child must live somewhere away from home. And also there can be conditions around restricting the child's movements, if that is considered to be in their best interests. And also, ultimately, there can be measures taken, such as authorising that the child reside in secure accommodation, but only for so long as is considered necessary, and with the agreement of the Chief Social Work Officer and the manager of the secure accommodation establishment. So there are conditions that can be attached, and the local authority have the duty to ensure that those services are provided. The question about whether they're always there is a much wider question, because that relates to current capacity within children's services widely around Scotland. That's perhaps a different issue to explore.
Okay, thank you, panel. Convener?
Thank you. Can I kind of turn the conversation around to the victims? One of the things that has changed in the lifetime, well, for two things, I should say. Firstly, some of the evidence we took, given that the petition began in 2022, the committee's evolved, so not everybody who is on it now was there then. But I was here at the time and able to go out to the various places that we were able to go to hear from people who were victims. And one of the things that's changed the lifetime of my being a member of this Parliament is smartphones and digital technology, and the way in which what everybody thought at one time was going to be a great asset to life is in all the cases that I heard about used now by young people to glorify the violence that is perpetrated. They feel free of prosecution because of their age, but which victims then find lies permanently in the accessible of the kind of humiliation and grief and suffering they served. And they feel that no weight is attached to the ongoing suffering of the victims in all of this. So I'm interested in a general sense, what would you say the support, protection and information that is currently available for victims of offences committed by children in both the criminal justice and children's hearing systems, and what you think will change as a result of the 24 Act? And do you think that the way in which victims are being kind of protected in the longer term is keeping up with the way in which the digital environment and the life in which they operate and live in is moving forward at pace as well?
There are a number of aspects to your question there, Mr. Carlow. I hope that I can cover them in my response. I understand your sense of profound change over this subject matter over the period that you've described. in relation to the offending, the nature of the offending, and the impact of the digital age on the victims of these crimes. We see that day and daily in the work that we do, and we constantly seek to strive to respond to societal changes that impact on the nature of the work that the prosecutors in Scotland do. So dealing firstly with societal change, which is fundamental to dealing with issues of sexual violence and violence. I would say that tackling this substantial challenge will take a wide response across the whole of society. In families, at home and amongst peer groups, in education, health and the third sector, it's vital that people across Scotland challenge harmful attitudes developing in young people. While we maintain focus on tackling offending through robust prosecution decisions, we also support broader societal efforts to promote healthy attitudes towards relationships and consent amongst young people, and healthy and informed attitudes to the use of digital devices. The response from the prosecution service is only part of and must be part of a wide strategy that includes appropriate education for children and for their parents. So dealing with the support and protection and information for victims during the process, I am acutely aware of the trauma experienced by victims and their loved ones because of the dreadful crimes that we're dealing with here and talking about. And the Crown Office and Fiscal Service is committed to improving the experience of victims within the criminal justice system. So we do ensure, as far as we can, and I'm really working hard to make this better, that witnesses and victims are provided with information and updates about the cases that they're involved in. Where someone is a victim of sexual crime and is under the age of 18 or involved in a jury trial, they are automatically referred to the Crown Office Victim and Information Advice Service, known as VIA. They provide victims and witnesses with updates on the progress of their case, including bail decisions, hearing dates and cases or court outcomes, and seek information to support applications such as non-harassment orders. They also engage in providing extra support for victims in court if they're required to give evidence by applying for special measures, and ensure that witnesses have access to their witness statements in advance of trial and met with the trial prosecutor in advance of giving evidence. We have a protocol with the Scottish Courts and Tribunal Service and Victim Support Scotland to ensure that all victims and witnesses have access to court familiarisation visits and at court support, and in addition provides case-specific information, victim and information advice, signpost victims to other agencies who can provide them with specialist support and advocacy services where required. And we do see the enormous benefit of these support agencies assisting victims and witnesses in these cases. Their input is vital to the wraparound service that victims and witnesses do require to go through the criminal justice system, which is traumatic and difficult and requires an immense amount of support. I think historically we haven't done all that we could have done there, and there's room for improvement, but I am seeking to improve things by trying very hard every day to improve communication, support, improvements in correspondence and better support for victims in court through victim support services and through meetings with prosecutors both before and after court. So there's a lot to be done and more can be done, but I absolutely accept that the victims during the process have to be front and centre of this response by the Criminal Justice Service, because it's only by giving that level of support that the public interest will truly be served and victims and witnesses will give of their best in the system.
Well, sorry, I'm grateful for your expression of empathy there with the victims and the efforts that you've been trying to progress in relation to the changes that have been forthcoming. I mean, earlier just focusing on victims, I mean, you made reference to the new statement of prosecution that states that under the UNCRC, the best interests of the reported child and other children should be given primary consideration. And we understand there is no hierarchy of rights. But we've heard throughout our work in this area that young victims feel that their rights are brushed aside in favour of the reported child. For example, on youth violence, and I come back to the two examples that we heard from. The first was at the Love Milton Community Centre. Now, there we heard from a young girl who was with her parents, possibly not the most socially adept girl within her year group, befriended by one of the people in her class and invited to meet her at an external destination. And when she got there, this was the girl who found there were about 5 or 10 people with phones who then recorded what was the most horrendous explosion of violence upon her, left her very, very seriously injured. And really for a while with some concern as to whether her life was now at risk. The children were all 12 at the time. They were all young. She now no longer feels safe to leave the house for school, or at the time didn't, or socialising for fear that this would all happen again, that it was all recorded publicly. Her mother felt very much that while the police were incredibly supportive, they felt that this wasn't going to go anywhere ultimately, and that there seemed to be a tremendous amount of support in place to try and have the individual who committed the offence understand the nature of what they'd done, understand how filming it had been deeply harmful, but that individual was still in the community and that individual's parents were tormenting this girl's family and saying, there you go, there's nothing you can do about it, so that her young daughter felt she was locked up at home with no education, no counselling or social life. And you ask we ask ourselves, how is the long-term impact on victims taken into account when determining what the appropriate justice route might be for reported children? Who ultimately really is representing in the consideration of an example like that the interests of that victim? And even in so far as those interests are represented, what weight is actually finally given to them in terms of how matters progress?
So, what you've described to me sounds as if that the child and the events of what happened to her were reported to the police. And the police have publicly published guidelines from me that set down the circumstances in which they must report offences committed by children to the Crown Office and Procurator Fiscal Service. From what you've explained, I'm not clear as to whether or not, in that case, the police reported the matter to the Crown Office and Procurator Fiscal Service, because in serious levels of offending of the nature that you have described, it very much seems to me, just on the information you've given to me, that that would be the type of offending that should be jointly reported to the Crown Office and Procurator Fiscal Service and the Scottish Children's Reporter by the police. And then, if that were so, and it came to the Crown Office, there would be, as Mr Hogg has described, communication between the Children's Reporter and the Crown Office as to what should be done in the circumstances of that case. And in that connection, all of the circumstances of what happened are taken into account, and the rights of the victim and the rights of the accused, and the whole circumstances of the case, including the level of seriousness and the impact on the victim, are all factors that are weighed in the balance with great care and great seriousness before ultimately a decision is taken. Now, the Crown can prosecute cases, and they do that, and they do provide during the course of the prosecution the level of support to victims that they can through the Victims and Information Advice Service, and the support that prosecutors can give to victims of these types of crime through the criminal justice process. Separately and distinct from that, victim support agencies are available to provide support. But we can only prosecute, and we can't prosecute our way out of what is a very difficult situation for all of society that relates to offending in relation to children. But we can do our part, but it has to be a whole system response, as I was saying before. And if, in fact, the system itself is not providing separately and distinctly the appropriate level of support for victims of these types of crime, then that should be looked at. And I would support anything that would do that to the utmost of my ability and within the parameters that I'm able to operate within. Perhaps Mr. Hogg could also respond to your important points.
Yeah, of course. Maybe would kind of focus mainly on, I know you raised other issues, Mr. Carlow, but in relation to support, protection, information for victims. Because a lot of this discussion took place during the passage of the Children, Care and Justice Bill as it was and Act as it's now become. And there was recognition of a lot of the issues that you've described. I'm certainly aware of the views that you've expressed from that particular victim from an incredibly traumatic incident that they have suffered. And it's a familiar narrative that there is a perception that the child it's often a child who has been harmed by another child, feels that they have not been provided with the same level of support as the child who has caused the harm. Now, it's a perception. It may not, in fact, be the case, but it might be. But what's important is that that's the perception, and that needs to change. That has been recognised. It's been recognised through a number of different routes, and the Children, Care and Justice Act has in place provisions that should at least begin to go some way to addressing those concerns. At the moment, there is a limit to how much information can be shared when a child is referred to the Children's Reporter and to the Children's Hearing System. That is, of course, because of the rights of a child to privacy and confidentiality, and that has to be balanced against the rights of the victim and their family to know what is happening. At the moment, the amount of information that can be shared is prescribed in statute, and it's very restricted. We can only say what our decision is and what the decision of the hearing is without any further detail. The Children, Care and Justice Act broadens how much information can be shared and has a specific focus on safety planning, safety and risk planning around the victim. It also places a duty on, I believe, the Scottish Government to ensure that supports are in place for victims, and will be setting up what is referred to as a single point of contact service for victims, where they can be provided with that broad suite of information that will help to understand what is happening in relation to the child who has caused the harm, and will also either provide or at least signpost to the provision of therapeutic services that might be required to deal with the trauma that they will have suffered. So there is that is all in place, and there are currently lots of discussions, workshops, design discovery phases going on to scope and design that service and what it might look like. And there is also work that is beginning in relation to quite complex new provisions around information sharing, when that can be provided and the circumstances in which it's appropriate to do so. I would also add that we have almost completed some research of our own. We commenced that following some parliamentary debate during the passage of the Care and Justice Bill, and it's likely to report in August of this year. And it's looking at what will help and support the victims of children who cause harm, and will contain, no doubt, some recommendations in relation to that. So all of that will inform what happens next. I would just also say a word of support for the Lord Advocate, because, as she says, she has really championed the cause for victims and taken it to a different level. And that has been principally through the vehicle of the Victims Task Force, which the Lord Advocate jointly chairs, I think, with the Cabinet Secretary. And Scottish Children's Reporter Administration are part of that task force. So there is a lot of action that has been taken. You referred to the fact that these petitions were 2022. So there's a lot of action that has been taken since that time.
Yeah, well, the petitions are 2022, but as we took evidence subsequently, it was from people to illustrate the issues raised by the petitions rather than by the petition themselves. Lord Advocate.
Carlo, it might help. I think Ms Ross knows of the case that you're talking about and would be able to just to fill in the gap that I was unaware of. If that's appropriate, you could just...
As long as we keep it all very anonymised, obviously, yes. Because we're trying to be general here without identifying anybody. But yes, that would be helpful. It might just help to see what actually happened without naming individuals. Yeah. Ms Ross? Good morning.
Good morning, thank you. Thank you, Lord Advocate. It was just really to, as Lord Advocate indicated, fill in the gaps if that was to be helpful. I am familiar with the circumstances of the particular case, but keeping it general, following on from what the Lord Advocate indicated, in that particular case, it was reported to the Crown Office and Procurator Fiscal Service. It was a case in which the presumption was rebutted and the case was indicted at sheriff and jury level into court. The outcome thereafter is, upon conviction or any plea of guilty, is a matter for the court. And I think if there were to be a referral to the children's reporter at that stage, which the court are entitled to do and did so in this particular case, that is a matter entirely for the judiciary. But it was a case that was reported, indicted into court by the Crown, and thereafter remitted to the children's hearing system by the presiding sheriff. There was a conviction.
Yeah, okay. Well, thank you very much for that. I mean, just before I move to Fergus Ewing, I was struck when we began that in response to Mr Golden, you made the point reasonably that prosecution is just one part of the way in which all of this has to be dealt with. And I don't suppose there's a right answer to this. I'm just interested in your opinion. Shortly before he died, I did a programme with the late First Minister, and one of the questions that was asked before, in fact, we went on air, it was a preamble, was about the use of digital technology and devices to intimidate children and to, lead to their bullying, exploitation or whatever. And it was interesting that the panel of adults all said what they had to say and the audience all did their usual kind of, yes, that sounds very reasonable, and applauded. And after it was over, some young people who'd been in the audience came up to me and said, you adults haven't got a clue as to what is actually going on any longer in the whole digital era. You're all too old. You don't really understand the pace at which this technology and all the apps and ways in which it can be used are developing. And so you're kind of approaching this in a sort of very noble way, but in complete ignorance of really what's going on the ground with these issues and the way they're being deployed and how it moves from one day to the next. And I wonder, I felt standing there as a 66-year-old adult, I realised, well, it's probably true I haven't the faintest idea how all these things are deployed. And in the challenge that you set of the wider society and understanding the harms and ways in which violence is being perpetrated and the digital mechanical, the technology way is being deployed. Is the justice system, is everything that the prosecution system, the Crown Office, is it the way in which, as I say, are we able to keep up with any of this, or is it moving at a pace which presents a challenge, the scale of which it's very difficult to grapple with or know how to properly respond to?
I think that's a very good point, and there's multi ways that that could be answered. I do believe that the Police Service of Scotland are fundamentally committed to the proper investigation and detection of crime and seeking to ensure that our communities are safe. And I do believe that they respond where they can to the challenges of the digital age. And insofar as prosecutors are concerned, we do prosecute many very difficult cases that involve the aspect of the presentation of a vast variety of types of evidence that emanate from digital devices. Just one example of a case that I prosecuted many years ago now was at that time the largest paedophile ring in the United Kingdom. And they were a group of 8 men who were prosecuted for committing crimes against children. And for the very first time in the history of Scotland, we prosecuted these men for conspiring to sexually abuse children because we were able to detect them as a result of tracing their actions through their use of the internet and the sharing of indecent images over their internet sites. And we were able to, through the good policing, secure evidence from America that related to their contents of their inboxes. We were able to secure evidence from their digital devices and present all of that in court to secure convictions of all 8 accused. The 2 of the most serious offenders were convicted of committing a sexual act on a baby, and the baby was identified through a digital image that we secured from the Hotmail inbox of another accused. We were able to trace that digital image through expert evidence that got the thumbnail of the digital image. We connected it to the metadata embedded in the accused's own computer. And then we also used very basic policing through hand identification to link an image of the accused's hand to the image on the digital image that we recovered that showed him sexually abusing an infant. So we have for a long time challenged ourselves in the Crown Office and Prosecutor Fiscal Service to constantly try and revisit how it is offending is taking place and what methods and in what areas, and also to understand how all of this impacts on the children in our society. And I suppose we can always just think about how we adapt to changes in technology, but we also must always fundamentally remember what the basic problem is. In relation to the basic problem of violence against women and girls, it's the deeply misogynistic attitudes that are held within society and societal norms that allows the wide-scale abuse of women and children to happen in plain sight without the appropriate response from society to deal with it. So I go back to what I said at the beginning. Societal response is essential to the enormous problems that we are talking about today.
Fergus Ewing.
Thank you, Convener. Good morning to Lord Advocate.
Good morning.
We are here in this committee to give voice to petitioners, and the petitioner in this case is Julie Mitchell, who I understand has been in contact with the Lord Advocate. And the petition is ultimately about the point of principle, and the petitioner stated in her submissions that rape is an adult crime and should be treated as such. And in her submission, she added that this is what she said, Lord Advocate: I have found that if perpetrators are under 16 years in Scotland and charged for their crimes, they are automatically referred to the Scottish Children's Reporters Administration, giving them the opportunity to carry on with these types of behaviour because the victim and the perpetrator are both treated as children. The consequence of committing rape, which is a criminal offence, isn't a charge with the record of sexual offence. Instead, they are referred to the reporter and can be given behaviour therapy and not a custodial sentence. I ask why. The victims are left with a lifetime of difficulty and trauma. It doesn't just affect the victim, it ripples out into the close family. So the principle that we were asked to pursue and have pursued and widened it out perhaps, Lord Advocate, is pretty clear, and information has been provided by yourself and your office about the numbers of cases of rape or attempted rape and serious sexual assault reported for 12 to 15-year-olds, for under 16-year-olds, for each year from 2018 to 2023. It's helpful that that was provided. And they have, in the case of serious sexual assault, risen from 62 in 2018 to 92 to 2023, a rise of around 50%, which is worrying. And also the charges of rape or attempted rape have been on an upward trajectory. And the first question I have is this, that what we don't appear to have is a breakdown of these figures. How many of them in each year went through the adult system, and how many were referred to the SCRA? Now, I appreciate that it's been indicated by Ms Ross that the courts can refer the case to the SCRA, so that's an additional complication. But I think, to be fair to the petitioner and to those with an interest in society about this, it's probably most of us, really, given the abhorrent nature, as you've said, Lord Advocate, about these disgusting, repulsive crimes, that we do get to the bottom of whether the petitioner is right. Are most of these cases, if not all, dealt with by the reporter or not? And I still don't know the answer to that question. The petitioner plainly believes that they don't go to the courts, they go to the reporter. So I guess the first thing I'm asking, and I don't imagine you have those stats to break down today, but can, after this meeting, you provide us with a breakdown showing how many went to the reporter in each year, how many went to it would be the Sheriff Court or the High Court, I imagine, depending upon the nature of the crime and the circumstances involved, and how many of those were then referred back to the reporter, because the feeling is, I think, that this is still something that where those people charged with the most serious offence of rape end up being treated not in the criminal justice system, but in a more lenient way. And from the victim's point of view, one can readily understand how much anguish that must cause, especially in the most serious cases.
Well, I suppose the first point is, can or should children accused of rape be treated as adults in the criminal justice system? So we know that the prosecutorial response in relation to children and adults does require to be different. And fundamentally, a child is treated as such because of the impact of their age and maturity and how you then go on to assess their culpability, and the potential for them to change and be reintegrated into society and reducing the risk of offending. And the Crown also has a legal obligation to act in a child's right-based manner compatible with the UN Convention of the Rights of the Child. So that's the starting point. The question then is, in relation to a child who's accused of rape, what happens? And in accordance with the guidelines that I've issued to the police, the case, if it's a child, is reported to the Crown Office and Prosecutor Fiscal and to the children's reporter. And then there's a discussion between the Crown and the children's reporter as to what the appropriate steps should be. The Crown can then either, if they decide to take the case, prosecute or divert from prosecution. And in relation to the diversion from prosecution, you're aware from the evidence that we've given to the committee that there was a significant revisal done or a revisitation done of these guidelines that I instructed, and there are new guidelines in relation to diversion from prosecution that put the rights of the victims at its heart and ensure that there's better communication with victims of these types of cases where the issue of diversion is being considered. In relation to diversion, I think it is important to understand that it is a long-term tool for public protection. And the alternative to prosecution, namely diversion, is not a soft option, and it is actually it is actually often the most effective response for preventing future harm. In relation to those cases that are prosecuted, we can explain that we have looked at all of the cases that were subjected to diversion over a period of time. Over the last 5 years, we looked at the last 5 years of cases, and we'd be able to give you the numbers of cases that were diverted and the numbers of cases that were referred to the reporter after today. And we will be able also to give you the new figures that relate to diversion post my new instructions. But I think, Ms Ross, it is... We've got them. I don't want to yeah, we can put these in writing to make sure they're absolutely accurate. But in relation to those cases that have been the subject of the new guidelines, I think in relation to 10 cases, only 2 have been diverted. Yeah. So we've prosecuted, from the last 10, we've prosecuted 8 out of 10. But we can give all of the figures,
well, it would be
because I realise it's really reassurance and information that the petitioner whose child, as I understand it, was so badly affected by this type of crime and the impacts that she describes on her child, we really understand, and we have vast experience of. I understand what she wants to get out of this, and we can give you all of the information that you've asked for, Mr Ewing.
Well, I'm grateful to that, Lord Advocate, and I understand what you say, I understand the arguments, but would simply say that from the family of a victim of rape, a subsequent diversion is a bit late, and best diversion is, of course, as we all know, before a serious criminal habit happens, but that's another topic. But just can I pursue some of the points you've raised, please? You've alluded to the review of diversion from prosecution, which took place, was announced in July 23 and was then expanded, and as a result a new statement of prosecution policy and referral to the principal reporter on rape and other solemn level sexual offences where the accused is a child, was published by Crown Office on 28th April 2025. I mean, are you able to summarise what is different about this new approach? Because I think that's really what people want to know. Has anything actually changed, or is it the same? Now, the implication of the figures you've just quoted of the 10 cases and 8 going to the criminal system and 2, that might just be anecdotal, but the implication is that the new system is tougher in the sense that there is greater likelihood that cases of serious sexual assault or rape or attempted rape will be more likely now under the new system to go to the criminal justice system through that rather than the reporter system. Is that correct? And if not, are you able to outline in simple terms what has changed about the new policy?
Yes, so in simple terms, what has changed about the new policy is essentially a better focus on the aspects of a child's offending that would merit, that leads to the decision that there's a merit for prosecution. So there's a better focus on the factors that the individual lawyer should take into account in deciding whether or not that the case merits diversion, or at least a consideration of a diversion or prosecution. I have also instructed that before cases of the type that we're discussing today are determined appropriate for diversion, that these cases have to be considered by senior Crown Counsel in the Crown Office. So those advocate deputies that are senior, who hold my personal commission, are the ones that take the decision. So the the decision making is at the high end of Crown Office, in the sense that it's taken into the jurisdiction of Crown Counsel and the senior level of prosecutors. And in relation to cases of rape, diversion for adults is only seen in exceptional circumstances, and in relation to cases of rape involving child accused, the rebuttable presumption and the reasons for that presumption to be rebutted are very well focused in the published guidelines that are available to the public on the website. And they include aspects of where, for example, there's been a use of force, there's been manipulation of the victim, there's been repeat offending, there's aspects to the case that really cause the prosecutor real concern over the depth of the offending. So I do believe that it's a sound reset of prosecutorial policy that's informed appropriately by the concerns of individuals that we took into account. We were very much aware of the criticisms that were being made publicly about the use of diversion in these cases, and we responded to that by reviewing all our cases over the last 5 years. And I do believe that the refocus and reset in these guidelines gives a far clearer steer to prosecutors as to the decisions that they should make, and emphasises the importance of the victim's involvement in this process, and highlights, beyond peradventure, the seriousness of the offence of rape.
Well, thank you. And I was aware that the new policy sets out factors that may indicate a child should be prosecuted. And you've alluded to some of these: severe harm to the victim, including physical and psychological harm and trauma, evidence of the use of force along with the use of violence, threats of violence and or coercion, or coercive control. But in the text I've got here, where these serious impacts and serious criminal behaviour has been alleged, the implication is that there will be a prosecution, but the actual wording it says is that it may be a prosecution. So plainly there is a discretion, I understand that, but because the word may is used rather than shall, even in those serious cases, it still does kind of leave a sense that in some cases where the victim feels there should be criminal prosecution, there will not be. I mean, are you in short saying, Lord Advocate, that the new system does mean that more serious cases are going to prosecution? Is that it? Is that something that you'd be happy to say? That's the implication I get from your whole demeanour, which I absolutely respect, and the work that you and your staff do. It's incredibly difficult, which I understand. And the senior people dealing with the cases now, that's undoubtedly a major step forward. I accept all that. But, I mean, can you actually say now more of these serious cases are now going to go to the criminal justice system than was the case before the new rule?
So I suppose it is early days in the sense that the new guidance has only recently been published, but on the figures that I've given you, we can see what the position is. But I suppose the best way to be able to answer that question is to come back after a longer period of time to give data that demonstrates whether or not that's just so. I think it would be a mistake to say this is clearly the position now. I think the sensible thing would be to look at the data in the longer term. But I think that you understand, Mr. Ewing, that we do aim to protect communities while recognising that children who offend are still children, and we have to be proportionate, fair, and look at long-term outcomes as well as short-term punishment. And these are the challenges that prosecutors wrestle with day and daily when they're making these very difficult decisions in these cases. But we do take an evidence-based approach, and that doesn't mean we turn a blind eye to offending. Also, alternatives to prosecution are not a soft option. They're often the most effective response for preventing future harm. In relation to the way that victims feel about this process, I see that there may be a gap in relation to what the system provides for them, and that may very well be a very important outcome of the work that this committee is doing. What better support do we give victims of these crimes, where it is the case that those who are deciding these cases, often on fine margins, take a decision to divert or to refer to the reporter? What is the support there? We've tried to make sure that we engage with victims, explain to them what's happening, tell them about the processes that have been followed, explain to them about the diversion process and what's happened through that. Obviously, when it goes to the children's reporter, we no longer have an opportunity to engage with the victims. So there might be a bit of work that would be of merit in and around the very issue that you're putting your finger on.
Yeah, I appreciate that the new prosecution policy came in just a couple of months, just 2 months ago, nearly. So, as you say, Lord Advocate, time will prove whether or not the policy is new in terms of how it handles these matters. But we do have information published on the 10th of June, actually, the main findings from the Scottish Crime and Justice Survey. And I understand that these report a really quite alarming increase in the proportion of violent crime committed by offenders under 16. In 2021 and 22, it was 8%, but in more recently, for 2023-4, it was 31%. I mean, that's nearly a third of violent crime committed by children, and a rise of nearly 400% in 2 years. Now, I've just plucked 1 year. I think if you go back before to 2008, it was 14%. So it's a complicated picture. But the sense I get is that violent crime by under 16-year-olds, by children, is on the rise. And that in turn suggests, and I'm just, I think, perhaps reflecting what many people, constituents, tell me, that punishment is now a soft option. And it's not a deterrent. And that's why some youngsters think that they can commit crime, even serious crime of violence, not just less serious crime, although crime nonetheless of shoplifting and nuisance and breach of the peace and all that sort of stuff. But, you know, violent crime is going up amongst youngsters, obviously a tiny minority of youngsters, Lord Advocate, but is there not a worry that the current system is just failing victims because of the alarming increase in, as you say, children committing violent crimes? So do we not already have a sufficient corpus of evidence on which to conclude that there is a need to show that violent crime will be treated extremely seriously by the justice system?
Well, I think that violent crime is treated extremely seriously by the justice system. The issue that we're dealing with here today is just one part of that. And dealing with this issue today, I was deeply concerned by the increase in reported sexual crimes and crimes involving children. And it is a complex issue and requires a response not just by the prosecution service, but by the whole of the criminal justice service at large. The figures that you have quoted, I would need to look at. I'm not familiar with these statistics that you've just given me today, Mr. Ewing. We can look at those and we can do a piece of work in the longer term responding to the inferences that you've drawn from these figures. But I do fundamentally believe that prosecutors take reports of serious violence and serious sexual violence extremely seriously, and we prosecute young people in the adult courts for these types of crime, and we do prosecute a good number of children, and we can provide you with the statistics of the number of children who faced adult prosecution in the last 5 years, and it is a significant number.
Well, thank you. Just the last question I've got is, and,
Very quickly.
thank you.
The Cabinet Secretary.
Oh, I'm sorry. Yes, just one question is that the key aspects of the new policy are that the views of the victim should be obtained before deciding whether to refer to the reporter or not. Does the victim have a say in whether or not there should be a prosecution? And in what way, under the new rules, does the victim have a greater say than the victim had before, given that all too often victims feel bystanders in the justice system who are not kept advised about what's happening and often feel deeply disappointed by what has happened, although, again, a huge amount of good work Lord Advocate has done by the police and others, as I know. But what is new, what is different? In what way will the views of the victim be treated more seriously under the new policy than the old policy?
So the new policy does have a specific part of it that details the level of communication that's required with the victim. And this is at page 2 through to page 4 of the guidance that's publicly available. And obviously I'm aware of the short time that we have available, but I think we can provide guidance, and we've set down what the exchanges with the victim require to be over the lifetime of the case, that is before the decision is taken to divert and thereafter. And this is set out in fine detail in the guidance. But more importantly, I do believe that it's the change in culture that I have sought to engender across the whole of the Crown Office and Procurator Fiscal Service in relation to the importance of victim engagement, and not just formulaic but meaningful engagement that does leave victims feeling that they've been listened to and that their rights have been heard and that the criminal justice system has responded appropriately. So we can provide guidance, and the guidance is excellent because it has taken account of a lot of work that was done by those who were involved in the consultation process. And it was a huge consultation process involving key stakeholders, victims, lawyers, victim support groups, people across the whole of the justice system were involved in the consultation exercise. So the combination of that consultation, the new guidance that we give to prosecutors about communication with victims, and the shift in culture that I hope that I have been partly responsible for, I do believe will result in victims feeling that they've been listened to and not left behind. But I do think beyond what I can do as leading the prosecution service, there is room for visiting what to do for victims in a situation where there's no prosecution, or there's a prosecution and there's an acquittal, or even there's a prosecution and a conviction, and they are left picking up the pieces that the process of prosecution cannot give them any support for. What do we do for victims of crime that prosecution can't deliver? And that's a real question. And I see across the board that victims of this type of crime are fundamentally and substantially impacted by serious sexual violence, and the import of this type of offending across society isn't properly understood and should be. And I see that that's probably part of the committee's emotional response to what they have uncovered in the work that they've done here.
Okay. Lord Advocate, Mr Hogg, Ms Ross, thank you very much. I very much appreciate the time you've given and the evidence that you've been able to share with us this morning. And I suspend briefly. Welcome back to this meeting of the Citizen Participation and Public Petitions Committee. I apologise for the slight extension of the previous panel, and we're delighted that in this second panel we are joined this morning by the Cabinet Secretary for Justice and Home Affairs, Angela Constance, by Claire Collin, the Violence Reduction Team Leader, and by Tom McNamara, Head of Youth Justice and Children's Hearings. Good morning to you all. Thank you very much for finding the time. And I realise, Cabinet Secretary, your time is limited with us this morning, so we'll try and be concise. I'd like to start again just by setting out some of the context of the session. The committee has been undertaking considerable work on the petition to address youth violence and has been struck by similar concerns raised in the petition on rape committed by under-16s. These are both petitions that were first lodged in 2022. The committee, Mr Ewing will be rejoining us shortly, Mr Gold's had to leave us, but the committee itself has changed during the consideration of the various petitions, and indeed, I think I'm the only one of us left who actually went out to the Milton, the Love Milton Community Centre, and heard from some of the victims of one of the petitions. On the youth violence petition, we took evidence from Police Scotland, the Violence Reduction Unit and No Knives, Better Lives, and we took evidence from a number of academics, and also undertook those visits out to the community to meet young people in an environment where they felt less intimidated, perhaps, than they might have done if they'd been coming here to the Parliament to give evidence on their experience. In particular, we met a young girl who, at the age of 14, was lured by the use of mobile phone to a remote location where she was seriously assaulted by another girl that had falsely sought to befriend her. The whole thing was recorded on video, on mobile phones. It was all posted onto the internet. This left her, nobody with concern for her welfare, but she in due course was discovered and was taken to hospital with extreme injuries, and that's left her scared really to leave the house, and feels very much that the perpetrator is out and about in the community, the family even intimidating her family, but leaving her as a victim completely unprotected and unsupported. Her mum says she's now got PTSD. She's attempted to take her own life on 2 occasions. And the lasting impact on the young girl and her family, she said she always thought that police were here to protect and the justice system served justice. However, she just feels let down. And I suppose it's very difficult to understand how you would feel in those circumstances if you were a parent or if you were the victim. And as I outlined at the first panel, the committee understands that the policy position is to avoid criminalising children where possible. However, we remain concerned about the most serious of cases of violence and sexual offending are addressed, and crucially how victims can meaningfully pursue justice and feel safe in their community. Now, I understand, Cabinet Secretary, you might want to say a few words just before we move to questioning.
Well, thank you very much, Convener, and good morning to colleagues. And I very much appreciate the opportunity to join you this morning in your deliberations. I will just make a few very brief remarks, Convener. I do think it's important to start by saying that the vast majority of our children and young people are law-abiding and do not engage in offending behaviour. Overall, referrals to the Children's Reporter on offence grounds have decreased by over 15% in the 2024-25 year in comparison to 23-24. Police Scotland's own figures show that the total number of serious assaults by 11 to 18-year-olds has fallen by 27% over the last 5 years. Nonetheless, there are growing concerns and there is other information that requires to be acknowledged and addressed. And we've had the tragic instance and the loss of 3 young lives that we have seen over the last year that just demonstrates the absolute devastation and heartbreaking that youth offending can have. There is obviously work, and I appreciate committee will be aware of some of the work. There is work that we do through the violence prevention framework that we've invested more than £6 million in since 2023, and that is very much focused on prevention activities, including for young people.
We do know that more needs to be done, and that is why we held the summit on the 12th of June involving the First Minister and MSPs across the Chamber, as well as those involved in youth work and violence prevention. And that summit highlighted the importance of education, community engagement, youth work, creation of safe places, whole family support, and the role that that has in tackling youth violence. And of course we are considering what more needs to be done to strengthen this work for young people, families and of course communities. In terms of your own remarks, Convener, it is correct. We do want to keep children out of the criminal justice system where that is possible and where it's appropriate. And that's to ensure that children receive support to address their behaviour, as well as the needs and risks that they pose, whilst also ensuring, and this is crucial, that our communities are safe and that victims are fully supported. And of course any decision on whether to prosecute a child through the criminal courts or refer a child jointly to the principal reporter is of course a matter for the independent prosecutor. So happy to take questions, Convener.
Well, thank you very much for that, Cabinet Secretary. Mr Chowdhury is going to lead the question this morning. He's actually going to start with those 23-24 figures. I think you were just giving us updated ones for 24-25, but nonetheless, Mr Chowdhury.
Thank you very much. Thanks, Convener, and good morning. Since you've been giving us the update, but what factors do you believe are driving this increase?
So it's important to say that we continue to live in a safe country, that the long-term trends for offending overall, including youth offending, is going in a downward trajectory. What we have seen in terms of, I suppose, the Scottish Crime and Justice Survey and other information that in more recent times that we have seen changes in behaviour tends to be in and around schools, and we need to respond to that. And one of the reasons that the Youth Work Summit was really useful is in many ways it reaffirmed and added to our understanding about the change in behaviour for some young people and the causes for that. Essentially, I think you can boil that down to there is still a long shadow on some of our young people following from COVID and lockdown and being out of school and having more unstructured time and more time that was devoid of the normal socialisation young people would be having with adults out with their family and also other young people. There continues to be growing concern around online harms, and that certainly concerns me deeply, because what you are seeing is that bullying and behaviours that are being orchestrated online spilling over, into our schools and our communities. And there is also concern around, the third point I want to make is about online influencers. And how that is damaging the view that young men have of their own sense of masculinity, and that, of course, feeds into violence against women and girls as well.
Yesterday also saw the release of statistics which showed sexual crime on the increase. Do you know what percentage of this is under 16s?
So what I can provide committee with is that the most recent published data from the Scottish Children's Reporter Administration demonstrates that in terms of sexual crimes, there is a 9% reduction from 21-22 to 24-25. And I can, of course, in terms of the recorded crime stats, can go away and dig deeper to see if there is a breakdown of the age of offenders in any particular category. But what we do know from the Grown Up in Scotland study, as a longitudinal study, is that over the past 20 years, there is a significant decrease in youth offending amongst our young people. Now, that will be of no comfort if you're a victim or the family of a victim, particularly of violence.
Increase in the proportion of violent crime committed by children under the age of 16. Are you concerned about this?
Well, I'm concerned about any change. It is important to put this in context, and I put it in context only because we need to understand things better. But the context is, so if you look at information from Police Scotland, the number of serious assaults by 11 to 18-year-olds has reduced by over a quarter, by 27% over a 5-year period from 2019-20 to 24-25. However, they also advised over the same time frame, and this was information they recently presented to the Scottish Police Authority, that serious violence of young people in schools over that 5 period rose from 6 incidents to 40 incidents. So while those numbers may appear in total low, because they're across, these are Scottish-wide figures, but you can see concerns around that rate of increase. So of course we're concerned about that.
The Scottish Government's general position is that children should be kept out of the criminal justice system. What is the evidence base to support this position? Can you set out when a criminal justice response might be appropriate for children involved in serious violent and sexual offending?
So it's important to say that Scottish ministers are not the decision makers in individual cases that are either go to the children's hearing system or to our courts. But your question about evidence, Mr Chowdhury, is very important, because there is decades of evidence. And I'm afraid to say, Convener, I am old enough to remember what it used to be like as a former prison social worker and hospital social worker before I entered this place. I remember Pullman when it had several hundred boys in it. I remember the Young Offenders Institute at Glenacle, and I remember children coming in on a Friday night on unruly certificates when I worked in HMP Perth, and I remember the countless adults that I worked with, wrote parole reports on, who had came through the old Borstal system. So we also know that if children become involved in the criminal justice system, that they are less likely to desist from criminal behaviour, and more likely the risk increases of them becoming an adult offender, or indeed a long-term offender. And you will often have heard prison referred to as the University of Crime. And there are studies, the Edinburgh study of youth transitions, again longitudinal studies, along with the Grown Up Scotland study. And this recognises the causes of youth offending, and that it is more effective in terms of reducing offending to address the issues that young people who come into conflict with the law have with extreme trauma adverse childhood experiences, neglect, childhood sexual abuse, criminal child exploitation, and the feature of bereavement with young offenders as well. And that is why we have adopted that whole systems approach that first and foremost is based on prevention. Now, that doesn't mean that children and young people can't be deprived of their liberty. So there remains, a criminal justice response to that, either via the children's hearing system or for over 18s.
We have seen multiple stabbing committed by children this year. How would this be responded to by the authorities in regard to the perpetrator? As hypocritical, how would you expect a 15-year-old involved in a stabbing be treated by the criminal justice system, and what outcome would be the most positive one in the Scottish Government's eye?
So, as I said, it's not for a Scottish Government minister to decide the penalties or punishment for any offender, and that's very important, particularly if you believe in the separation of powers and the rule of law. I, like all MSPs, am under an obligation to support the independence of the judiciary. We passed legislation in Parliament, I think 2008, if I recall. But what is important is that the process responds to offending, and there's a range of factors that the independent decision makers, whether it's the judiciary or the children's hearing, have to take into consideration, and the impact on a victim is one. The severity of the offence, pattern of offending, and public protection. And in terms of some of the more recent legislation that this Parliament has passed, for example, the Children's Care and Justice Act, yes, that has been about enabling more children to go to the children's hearing system, but it's also been about enhancing the rights of victims, to receive information, and to things like widening the scope of offences that can be subject to movement restriction conditions, for example, and much of the work that I'm currently involved in, whether it's through the Victims, Witness and Justice Reform Bill, is around enhancing victims' rights, particularly around the victim notification scheme.
I think last question from me is, in terms of preventing children from committing serious violent and sexual offences in the first place, what is the Scottish Government doing in terms of prevention and early intervention? What evidence is there to demonstrate that it is working?
So the evidence is there in terms of the longer and medium-term trends in the reduction of youth offending. And I suppose there are two aspects to prevention and early intervention. And this is where I acknowledge as Justice Secretary that universal services in terms of education, in terms of health, in terms of early learning and childcare, support for families, support for parents, all of that is absolutely crucial, as well as the building blocks associated with an equally safe strategy and the funds that are routed through delivering equally safe. And then, there is another layer of, early intervention, which is about responding to those risks and needs that give cause for concern, because it is important that we prevent an issue or a problem from becoming a crisis. I've seen a lot of that in my previous working life, where problems have grown and become a crisis, and sometimes with very tragic consequences.
Thank you, Mr. Torrance.
Thank you, Convener. Good morning, Cabinet Secretary. Does Police Scotland have sufficient powers and resources to play its part in addressing serious violent and sexual offending by children under 18?
So I do believe that Police Scotland has the resources and the appropriate powers. Always open to dialogue. Of course, so my engagement, with, the police and family is very important in this regard. In terms of stop and search, police officers need reasonable cause to do that. However, there are powers under Section 60 of the Public Order Act. I think that's the 1984 legislation, where an inspector or above, if there are concerns about serious violence, can utilise stop and search without reasonable cause. So stop and search, for example, is an important tool, but it is only one tool. Police officers are also involved in the work that some campus cops do. They're engaging, with young people and children as well. Police Scotland have their youth volunteer programme also. But it's also important, convener, to be looking at the evidence. So last year there were 4,000, let me just get the figures. No, 6,000 stop and searches of young people. And that had went up by 35%. So that's the figures for 2024. The stop and search for young people in 2023 had been 4,500. So, big increase in stop and search. However, in terms of the number of bleeded objects that were found and retrieved, it was about the same. It was 151 bleeded objects in 24, 154 in 2023. So, it's quite difficult to isolate evidence that stop and search will reduce knife crime. It's a tool. It's part of a much bigger approach.
Thank you for that, Cabinet Secretary. It's not only police that have a role to play in addressing serious assault and sexual offending. Could you advise what other agencies have a role, and do you think they have sufficient powers and resources?
So there's a broad range of agencies that have a role. I mean, I'll start with justice, social work, and social work more broadly, because it's something I know well. Obviously, in terms of the management of people who offend, there's a huge role for justice social workers. They are not telling me that they need any more powers, that they need to, supervise, release licence or, community payback orders. I mean, I am interested in the work that's been done by our Independent Sentencing and Penal Commission in respect to work around our prison population, is whether we have the right breadth and depth of disposals and alternatives to custodies. But that's a bit of I don't want to go too off-piste from my purpose here today. Children and families, social workers are hugely important. Very pleased that my colleague Ms School-Ruth has invested in some additional financial support for student social workers, because there's a recruitment and retention issue, particularly for children and family social workers. And these are the social workers that will have, big child protection responsibilities. Obviously, doctors, nurses, school teachers, all have a responsibility in terms of safeguarding and to engage with other services when there's a well-being concern. So right across the public sector, there's a whole host of services that have very particular responsibilities.
No further questions,
Cabinet Secretary, I'll begin with a sort of anecdote that in the same characteristic that I put to the Lord Advocate. And it returns to this online theme that I think you addressed in the remarks that you've made to this point. And I referred to a television panel I appeared on with the late First Minister just before he died. And the introductory question, the one that actually wasn't broadcast, was about the use of online activity and the filming and the posting of online of attacks on young people. And the panel of adults, including him, we all gave what we thought were very worthy answers, and we got the usual kind of polite applause from the audience. And after the whole filming session was over, young people came up and said, "You adults haven't got the faintest idea what you're talking about all of this. You're talking about online and the use of digital technology, which is way, way beyond actually your experience of it. It's not how we as young people see it at all." And I wonder, when we're talking about the rapid development of digital technology and the way in which young people, and I referred to at the start of the proceedings to an individual who was lured, and the incident was filmed by a number of people that was then broadcast on social media. It sits there in perpetuity as a kind of legacy of the harm that was caused. Are we as kind of politicians and legislators keeping up with the way in which online activity is being deployed against young people in a whole series of different ways, but sometimes by young people themselves against other young people?
Well, I think that's the $6 million question, convener, and that is what we really have to challenge ourselves with, both as politicians and for those of us who are parents, because we're not sighted on all aspects of our young people's lives, and I think that's for sure. And I know that some of the work that other colleagues across government have done to, invest and ensure we've got the right content on the Parent Club website. Nonetheless, it's how do we, reach more parents and more adults who are involved in ensuring that our children are safeguarded and well. As a government, we have a very clear programme for government commitment, and I'm very pleased that Ms Brown is the Victims Minister and Ms Dawn Innes as the Children's Minister are leading the Online Harms Task Force. That's an important bit of work, and notwithstanding that regulation in and around online activity and online harms is reserved. As a government, we want to do everything within our capacity. We do need to be engaging young people in this, and in many ways they will guide us. As Justice Secretary, I am acutely conscious that in terms of figures that started to emerge a few years ago in terms of the proportion of young people who are either the victim or the perpetrator of sharing images or either being the perpetrator or the victim of online harm is significant. And that's why our services need to be engaging with our young people, and the realities of their lives. I mean, they are much more, tech savvy, I suspect, than anybody, sitting around this table. You may also recall, convener, that the Online Safety Act, where we engaged very closely with the UK government on that. So there are new offences that apply to Scotland, and that's around the criminalising of sharing of materials that are intended to encourage or assist in harming others. And, part of our work is to, raise awareness and make young people aware of the risks associated with these harms, but also the risks associated with breaking the law. We're also...
Sorry, Cabinet Secretary, do you know if that those new powers have actually been deployed? Have they been used? Have they been...
I don't have any figures at hand for that, but I can certainly...
Because it does appear to potentially contribute to the Scottish Government having the ability to intervene where online material is potentially being used in a damaging way.
Yeah, so it would be for agencies, for justice agencies to be intervening on that. So there is also, I mean, I'll see what information that I had. I just don't have anything at my fingertips right now. My apologies, convener. The information that I did see last night wasn't the most up to date. It was a few years old, and it spoke to the proportion of young people as victims and perpetrators of online offending. There's also the Quit Fighting for Likes campaign that was rerun in March, and will rerun later this year. That's ably assisted by the Scottish Violence Reduction Unit, and it's supported by an increase in funding to that organisation. And Miss Brown has led work on sextortion as well. So we're also getting into cyber-related fraud as well, which is exploiting our young people, luring them into sending images and then sending threatening remarks and materials about disclosing, and that, of course, that crime has had very tragic consequences for some young people as well.
Yeah, I've heard of that firsthand.
Yeah.
Mr. Ewing.
Yes, thank you. And good morning, Cabinet Secretary.
Good morning.
Officials. The petitioner, Mr. O'Kane, lodged this petition in August 2022 and said in relation to the disturbing culture of youth violence in Glasgow city centre, quotes, children as young as 13 years old have been kicked unconscious and left in pools of blood, whilst the incidents are videoed and circulated on social media. Since then, and in the year 23-24, the Scottish Government's main findings published in the Scottish Crime and Justice Survey of that year indicated that the proportion of offenders committing violent crime aged under 16 was 31%. And I raise that because it's a huge increase, Cabinet Secretary, on before. In 21-22 it was 8%. So it's risen by fourfold since the petition was raised, despite the petitioner raising, as I've indicated, a graphic example of repulsive violence. What's gone wrong? Why is there such a big increase? Is it because the justice is seen as a soft option these days, and because young people feel, rightly or wrongly, that they can get away with this kind of behaviour with impunity?
Well, there's nothing soft about our justice system, Mr. Ewan. And in terms of the Scottish Crime and Justice Survey, that is a very important flagship survey. It gives us very good information, and while the longer-term trajectories, speak to, a fall in youth crime in Scotland being safer, you're quite right to point to the proportion of violent crime where the perpetrator as a child has increased to 31% of incidents. And that's what I meant earlier when I said that there is newer information in the shorter term that gives cause for concern, and we need to acknowledge that, that it's not acceptable and that it requires to be addressed. In terms of when you say what's went wrong, I think that is the change in behaviours of some young people due to the challenges I spoke earlier. And I know people don't always appreciate this, but it was ably articulated at the round table chaired by myself and First Minister, that there has been an impact on young people's behaviour as a result of lockdown and COVID. The youth work leaders and those in the forefront of violence prevention, and of course teachers in our school, you know, will narrate that as a reason. We have spoke at length about those online harms that are exposing our children to outside influences, and that's an issue. And related to that is the influence of what's called toxic masculinity on some of our young men. And I think they are, you know, three important drivers of these recent changes. In terms of what's going to work here, so there is absolutely a value and a place for youth work. I'm a huge advocate for youth work, and you know, that is supported, for example, via cashback. We often think of punishment, and there's a place for punishment, but in terms of change in behaviour, young people need reliable, trusted relationships, and we've absolutely got to continue with work on prevention and not be swayed off that by thinking that we need to now put all our eggs into the punishment basket. We've got to continue to commit to the long-term preventative work, because we are seeing long-term improvements as a result of that. But there is no doubt that we need to be acutely aware and address these recent changes in behaviour of some young people.
Recently, I in speaking to a senior manager of a chain of convenience stores, small shops, where the staff in the shop may be one person, I've been told that his feeling, I won't name the company just at this point, but his feeling was that shoplifting is no longer prosecuted. Youngsters who engage in shoplifting know that that's the case. Attacks on shop workers are routine. These happen very frequently. I think they may even happen, you know, more than once per week in this particular chain. And the feeling is that shoplifting isn't really considered as almost a crime anymore, not prosecuted. Is that right? And is that something that is right, or is it wrong? And is shoplifting being prosecuted now, or have we just given up on that?
No, I know for a fact of cases where shoplifting is prosecuted, and you know, I certainly know of, you know, I can see that pertinent in the certainly in the adult system. So it is prosecuted. I think it is accurate to say that shoplifting is increasing. It's increased significantly, while crimes of dishonesty overall have had a decrease, and significantly so. We're still seeing challenges in and around shoplifting, and that is particularly damaging to businesses and will have shop workers and shop owners, you know, very fearful. And that is why, in terms of the budget that was passed end of last year, start of this year, that there was a resource specifically allocated to Police Scotland. It was £3 million to take forward work in and around shoplifting, and it's Assistant Chief Constable Tim Mears who's been leading on that work. And some of that work is about police presence. Some of it is about support to shopkeepers in terms of you know, being able to communicate and be alert to who's doing what, and that information being shared with police. It's a particular issue in particular parts of Edinburgh, but of course other areas in Scotland as well.
Just on the cashback issue, which Cabinet Secretary mentioned, and where I was involved in this in some years ago, so long ago it's probably of archaeological interest now, but when we set up, Kenny McCaskill and myself, the cashback scheme, the idea was to take money confiscated from drug dealers and other criminals, their fruits of crime, confiscate it, get it off them, and put it into helping to turn around youngsters, particularly those who were not criminals but were on the cusp, were about to, or were feared to be on the cusp of moving into criminal behaviour, perhaps involved in antisocial behaviour, perhaps involved in minor crime, although every crime is a victim. And there was a lot of work done on that. I just wondered if you're able to share, Cabinet Secretary, whether the 20 million that you've said in your submission is being devoted to cashback, supplemented, I think, by 6 million in a recent announcement I saw. Does that constitute all the money that has been confiscated from criminals, or is some of it siphoned off for other purposes?
So what I can say, so phase 7, for this 3-year phase, instead of it being 20 million, it will be 26 million pounds, and that is very much in response to some of those shorter term changes that we're seeing with the behaviour of some young people. If I can maybe give some examples in terms of your question, Mr. Ewan. So if I look at figures from 23-24, the total cashback expenditure was just under £6 million, forgive me. 24-25, it was, 6.7 million. And the forecast for 25-26 is 6.8 million. And what I can say is that, approximately, 90% of that goes on cashback projects. But there is, smaller amounts, allocate to staff costs and delivery partner costs.
Well, that's helpful. And it does look as if the lion's share, if not all of the money, is going to try to divert youngsters from behaviour. And I do understand, and I did get the impression that many of these schemes were pretty effective, although it's very hard to measure these things in outcome, obviously.
Just
finally, sorry, Convener, just are private companies still involved in partnership programmes with the government? I mean, I remember Coca-Cola, Jim Fox is very active in working with the Scottish Government, helped to fund a kind of a multi-five-a-side football competition in I think it's in central Scotland somewhere, and this proved to be very popular. I mean, there's a cost involved, but I just give that as an example, but I wonder if the Cabinet Secretary is aware of any examples, and if not, is that something that the Scottish Government could do a bit more of, to seek to work in partnership with private companies who may well have a direct interest, actually, in trying to turn around the behaviour of youngsters, but are public-spirited and would like, I think, in many instances, to be of help?
So, in terms of colleagues who will work in social policy, and I remember from my own days in social policy and to a lesser extent education, there was certainly discussion and support, particularly for our third sector organisations, linking in our third sector organisations with philanthropic organisations and foundations. And actually, I think probably maybe a good example of that, and I'm a wee bit rusty on that side of the house these days, is probably Inspire in Scotland. So there are a range of partnerships. I mean, probably as MSPs, we've all been involved in, bringing local businesses together with good causes in our own constituency. But I think Mr. Ewan makes an interesting point, and I'd be happy to write further to committee if committee wished.
Okay, thank you.
Right.
Well, I'm conscious of the Cabinet Secretary's time.
Very short, if you can't answer today, I wonder if the Army are still involved, because I found that, you know, sergeant majors and the type were actually the most effective at gaining the respect of certain young guys, mostly, and turning around their behaviour.
Involved
in prevention work, in diversion work,
so,
like in out-of-bounds schools, residential courses. Lots
sure.
of young guys get together, you know, they bond as a team, they're taught how to do certain things, they learn discipline, and gets them away from perhaps housing schemes where they've had a difficult time in some cases, many cases, I suspect. And so it was an effective means of helping prevent youngsters from going down a criminal path.
So I do think there, and there will be examples of the uniformed organisations engaging with young people. I know that Police Scotland have their schemes in terms of the youth volunteers, and obviously in terms of the military, you know, they have their cadets. And they are very visible, certainly in the community I represent, at local galleries and local events. So I think the point that Mr Ewan makes, that, you know, at the end of the day, this is everybody's responsibility. You know, these are our children at the end of the day, and, you know, we need to be, you know, exercising, you know, our responsibility to rear them well, to be safe and happy.
And I'm conscious of your time, Cabinet Secretary. Just very finally, you've referred to the various summits that have taken place. And I'm just wondering, are we yet clear of specific outturns from that, or is that still a work in progress? And do you expect that that might lead to a debate in the Chamber later in the year in consequence of the evidence that was heard there, which this committee might be able to participate in as well, given the evidence that we've been taking on the same issue over the course of this Parliament?
Well, I'll certainly share that with colleagues, convener. I'm not the sole arbiter of you know, government-led debates or business, and I don't want to get six of the belt from Minister from Parley Business. I know we've got a heavy legislative programme between now and Parliament rising. But I do think, I mean, the one thing that was really important about the summit, it is important that we talk, but then respond to what we have heard. And it's crucial that we engage with young people. There was a young person's summit earlier this year. And there is a value in engaging on a cross-party basis with people that are on the front line in terms of youth work and violence reduction and violence prevention work. There's certainly been some actions from that. So in terms of, you know, supporting the Scottish Violence Reduction Unit to and increase some of its work around, you know, online harms, for example. They're also going to be engaging with, you know, some young people who, you know, have perhaps higher risks, if I can put it that way. Round about the time of the summit was when we opened the phase 7 of cashback, and I think that was a good way of highlighting to organisations that, you know, there is, you know, funding there. We do need to do more in terms of those, you know, kind of 3 specific issues that are, you know, that are perhaps underlying the more recent change in behaviour in some young people. But there was a real commonality around the importance of prevention and early intervention. And yes, you know, you change and adapt and you implement and you do different things within that. But we cannot walk away from prevention, because we will do that at our peril. We've got to stick with that.
Thank you very much. That's all the questions. Is there anything you'd like to add just finally, or have we covered the ground that you were hoping we would this morning? Well,
just thank you very much, conveners, for the invite, and if I can be of any more assistance to your deliberations, I'll be only too happy to oblige, you know, in writing or in person or whatever.
Thank you very much, and thank you to you and your colleagues, and we now suspend. Thank you. And I should say that now brings us to the conclusion of the public part of our meeting for today. Our next meeting will be taking place after the recess on Wednesday the 10th of September. And we do as a committee now move into private session to consider agenda item 3. Thank you.